State your name.
Name is Daniel Magoo for the record, Your Honor.
You're going to represent yourself in this matter, sir?
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
Hold up. What happens when an overconfident defendant decides to play word games with a judge who has zero patience for nonsense? You're about to witness one of the most infuriating courtroom exchanges we've ever covered. Meet Daniel M., charged with assaulting a police officer, facing 2 years in prison, and he's about to turn what should be a simple arraignment into an absolute disaster. This guy lost custody of his son over these charges, but instead of taking it seriously, he's about to play semantic gymnastics with a judge who's not having it. Buckle up, because this self-represented defendant is about to learn why lawyers exist the hard way. Let's dive in.
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what? Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. Say your name.
Okay, pause. Did this man really just say, "I'm not afraid," when the judge is trying to warn him about representing himself? That's not courage, that's stupidity. The judge literally just told him he could face 2 years in prison, and instead of answering a simple yes or no question, Daniel decides to play word games. I comprehend what you're saying. Notice he won't just say, "I understand." This is classic sovereign citizen behavior. Folks, they think if they avoid certain legal phrases, they can somehow outsmart the system. Newsflash, judges have seen this act 1,000 times, and this judge is already done with it. The smirk comment? That's the judge basically saying, "I see your game and you're about to lose." Let's see if Daniel learns his lesson.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, Your Honor, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize that.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be,
Your Honor.
You have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat.
I overunderstand what you're saying. Are you kidding me right now? This man just invented a new level of courtroom stupidity. The judge asked him 5 times for a simple yes or no answer, and Daniel keeps dancing around with I recognize, I acknowledge, and now I overunderstand. This isn't just disrespectful, it's self-sabotage at its finest. The judge literally spelled it out. You'll be held to the same standards as a practicing attorney with no special treatment. And this genius thinks he's being clever by avoiding the word understand. Here's what Daniel doesn't get. Judges have absolute power in their courtrooms. You don't win by being a smartass. You win by following the rules and presenting your case properly. But hey, let's see how round 3 goes.
The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5-minute, 10-minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in Louis Juris.
All right. So on this matter, I was apprising you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still waiting.
I wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on a legally?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words "I understand"?
Sir, I'm not saying that you have to say anything.
Okay.
I am, you know what? Here's the thing.
Hold up. This just went from annoying to tragic. Daniel just admitted he lost custody of his son over these charges, and he's still playing games. The judge literally just explained the difference between understanding what you're charged with versus agreeing with why you're charged. And Daniel hits back with, "Can we agree to disagree?" Brother, This is not a debate club. This is a courtroom. You're facing serious charges that already cost you your child, and you're treating this like some philosophical argument about constitutional rights. The judge's patience has officially hit zero, and honestly, we don't blame them. Daniel thinks he's making some grand stand for justice, but all he's doing is digging himself deeper. The saddest part? A simple yes, I understand the charges would have moved us along, but his ego won't let him. Watch what happens next. This is where it gets real.
I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play this some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will. Do not interrupt me.
I can object to
Do
that date.
not
Prior
interrupt. Do not. One more time, you're going. I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may
violation.
leave now.
Let's go. Let's do
I have a right to a
You may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. Let's call the case of the People State of Michigan versus Daniel Magoo.
Whoa. Did he just try to object to the judge adjourning the case and then claim he needs counsel while simultaneously saying he doesn't need an attorney? This man is having a complete meltdown. I'm the only one that knows what happened. Yeah, buddy, that's what every defendant says. The prosecution has police officers, body cameras, and witnesses, but sure, you're the only source of truth here. The judge gave him multiple warnings, offered him an attorney, and Daniel still can't get out his own way. This is exactly why the phrase, a lawyer who represents himself as a fool for a client, exists. The most frustrating part? He had an attorney before and apparently fired them. Now he's realizing maybe that wasn't such a smart move, but his pride won't let him admit it. Let's see if the next hearing goes any better. Spoiler alert, it probably won't.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
OH, my God, the judge just played 4D chess. Instead of falling into Daniel's word game trap again, they simply said, I'm going to presume you understand English and move on. Brilliant. And did you catch that gum chewing moment? This man showed up to court chomping on gum like he's, at a baseball game. The level of disrespect is astronomical. The judge basically just said, I'm not playing your games anymore. We're moving forward whether you like it or not. This is a masterclass in judicial patience and strategy. Notice how the judge still offered him an attorney. Even after all his nonsense? That's professionalism. But Daniel's ego is so massive, he probably thinks he's winning. The prosecution is about to enter the chat, and trust me, they've been watching the circus too. Let's see how this discovery dispute plays out.
I'd like to move for evidentiary hearing or yeah.
You wish to have a preliminary examination?
Preliminary examination, yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that to sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We could try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
Wow. Just wow. Let's break down this absolute train wreck of self-representation. Daniel M. filed a writ of mandamus that got dismissed, claimed Brady violations that don't exist, doesn't understand that discovery doesn't have to include exculpatory evidence. If there isn't any, and literally just said, there's no evidence I did anything wrong, as if the prosecution is supposed to prove his innocence for him. This man doesn't understand basic legal procedure, can't file a proper motion with a hearing notice, and thinks semantic word games will somehow save him from charges that already cost him custody of his child. The judge showed saint-like patience, offered him an attorney multiple times, and Daniel's ego wouldn't let him accept help. Here's the harsh truth. He's setting himself up for conviction by being his own worst enemy. The preliminary exam is set for January 2nd, 2025, and based on what we just witnessed, Daniel is walking into a legal buzzsaw without any protection. If you found this case as frustrating and fascinating as we did, smash that like button Drop a comment below telling us what you would have done in Daniel's position. And subscribe to our channel for more jaw-dropping courtroom breakdowns. Should Daniel have just answered yes to the judge's questions? Let us know in the comments. Hit the notification bell so you never miss our next video. And share this with someone who thinks they could represent themselves in court. This might change their mind. See you in the next one.